May thank you, Lordship.
Yes.
I am troubling your Lordship. I want to move one urgent application today, my Lordship.
Why the urgency?
My Lord, I have been illegally detained by my GST authority in contravention of my GST Act, as well as law laden by this honorable court as well as honorable apex court, my Lord. Totally, my Lord, disregard of the provision of the Act, your Lordship, because they have not served early notice under Section 41, capital A. They have not given reason to believe, my Lord, as per Section 69 of the GST Act. Power conferred under Section 69 to arrest.
Okay, you have filed already.
My Lord, please go ahead. Everything has
Okay.
been done.
Okay, let's see
Ma'am.
if it reaches.
Good.
Yes. Yes.
Fabulous Lordship. My Lord, I beg to mention item number 4. My Lord, can I log me through this time? I'm yet to receive instruction, my Lord.
Petitioner.
I've taken consent from my
Yes. Learned counsel for the petitioner, Mr. Such and such present. Stop. Learned counsel, Mr. Tipapom, appearing on behalf of the respondents, all the respondents. Appearing on behalf of respondent number 4 and 5. Praise for how much time? 3 weeks time to receive instructions and to file the affidavit. So, learned counsel, Mr. You also appearing? Mr. K. Angami appears for. No, for respondent number 3, who has already filed the affidavit. Accordingly, list the matter after 3 weeks. Yes.
My Lord, I beg to mention item number 10.
10.
Yes, I have received instructions, so I may allow me 3 weeks time to file it.
Item 10.
I've taken consent from all.
Yes. Learned counsel for the petitioner is not present when the matter is called. Learned government advocate Mr. Tipapom prays for 3 weeks time to receive instructions and to file affidavit on behalf of the state respondents. Prayers allowed list of the 3 weeks. Yes.
My Lord, we can beg to mention item number 16 on behalf of Indian Medicinal IG. I'm informed that he's yet to receive instruction, so praise for 3 weeks time.
Petitioner.
Yes.
Yes, learned counsel for the petitioner, Ms. Esther is present. Stop. Learned government advocate Mr. Tipapom makes a mention on. Wait. On behalf of Mr. Im Tim Song, who appears for the state respondents and prays for 3 weeks time to file the affidavit on behalf of the state respondents. The prayers allowed. List after 3 weeks. Yes, item.
Similar prayer for item number 34.
Yes, you had.
34 I filed IA Lordship. This is for implement Lordship for EC Lordship.
Okay, then wait. Yes.
And my Lord, I beg to mention item number 25. Can you allow me 2 weeks time to? In the last occasion, I was directed to produce the report. So, can you allow me 2 weeks time to place the
You
report?
produce the records.
Yes, ma'am.
CGC is there. Learned counsel for the petitioner, Mr. Sergeant is present. The learned state government advocate, Mr. Tipapom prays for 2 weeks time. 2 weeks.
Yes.
2 weeks time to produce the records as directed by this court. Stop list after 2 weeks as prayed for. None appears for the Union of India when the matter is called. CGC is absent? Yes.
Yes, ma'am.
Yes.
Much more.
In that item 16, there's interim Lordship.
Oh, item 60. The interim order passed earlier shall continue till the next date. Yes.
Mr. Lordship, I should have like to mention item 23. Because for 2 weeks, we yet to receive instructions.
Learned government advocate Mr. M. Longkamar prays for 3 weeks time to receive instructions and to file the affidavit on behalf of the state respondents. So none appears for the petitioner when the matter is called. List after 3 weeks as prayed for. Yes.
I'm glad. Maybe this, Your Lordship. I should have like to mention item number 27 is late, Your Lordship.
Yes.
In the last interim prayer was listed on date 29 of January, Your Lordship. It had been wrongly listed. If the matter can come up with 29, Your Lordship.
Learned counsel Mr. M. Solo.
Lordship.
Mr. M. Solo for the respondent submits that this court had directed the matter to be listed on 29/1/2026 for hearing. However, the matter has been wrongly listed today. So accordingly, prays that it may be listed on 29/1/2026. Stop. Para. list accordingly. Yes.
Your Lordship, also beg to mention item number 20, Your Lordship.
26.
Your Lordship. Correspondent number 5, on behalf of is seen on Your Lordship. Your Lordship, if the matter can come about after 2 weeks, Your Lordship. The senior is in this possible.
You're mentioning on behalf of?
Is seen.
Okay.
Respondent number 5.
Okay. Learned Counsel, Mr. M. Solo makes a mention on behalf of on behalf of, where is the name? Name is not mentioned
Your
here.
Lordship is not reflected, but Your Lordship.
On behalf of, okay, on behalf of the council for respondent number
5.
5, who is indisposed today, and prays for listing the matter when?
After 2 weeks.
After 2 weeks. So learned counsel for the petitioner, Ms. Such and Such is present and has no objections. Learned government advocate, Mr. M. Longcomer is present, list after 2 weeks.
Lordship, this is.
The interim order passed earlier shall continue till the next date of listing. Okay, in item 27 and 28,
Lordship.
petitioner is not there.
Lordship, we have taken.
Have you taken their consent?
CPI.
Okay, so 27 and 28, you say that the learned counsel submits that consent has been taken from the petitioner, okay? Yes.
Lord, I beg to mention item 14. 14. My lord, here, it is a consensus prayer that the matter be listed on the 9th of January.
Okay. You are mentioning on behalf of?
The private respondent was.
Learned counsel, Mr. Such and Such makes a mention on behalf of the private respondent to list the matter on 29/1/2026 and submits that it is a consensus prayer along with the counsel for the petitioner. Stop. Accordingly, list on 29/1/2026. Yes, the interim order passed earlier shall continue till the next date. Yes.
Lordship, I beg to mention items.
Hmm.
The file is currently before the council minister, currently presents for this time.
What has minister got to do with the case? Item 6 and 7.
6 to 8.
Actually, item 6, I think someone had already mentioned, isn't it? Item 6 to 8. What is the matter about?
I'm not going to do with the matter.
Who's appearing for the government? 6, 7, and 8. Learned counsel and Ms. Such and Such appearing for the petitioner prays for listing the matter after 2 weeks.
4 weeks.
After 4 weeks. So, as there are some developments, I'll just say that as there are some developments in the case. Learned government advocate Ms. Levika appears for the state respondents, lists the matter after 4 weeks as prayed for by the petitioner. Yes.
Notice, Lordship.
Huh.
It's not to mention item number 9, Your Lordship.
Yes.
Because of this various difficulty today, Your Lordship. So
Hmm.
it is matter can come up on-
Who has difficulty?
Is way, Your Lordship.
Pisurin. Okay.
This matter can come up on 9 of February.
Okay. Learned counsel, Mr. Medovero makes a mention on behalf of the counsel for the petitioner, Mr. P. Suryan, who has some difficulties today, and prays for listing the matter on 9th of February 2026. Stop list on 9/2/2026 as prayed for. Yes. Learned government advocate, Mr. K. Angami is present for the state respondents. Okay.
Lordship, again, mention item number 11, Your Lordship. I think I've taken the consent from the other party, Your Lordship. This matter can come after 3 weeks, Lordship.
Learned counsel for the petitioner, Mr. Medovero, prays for listing the matter after 3 weeks and submits that the consent of the other side has been obtained. Stop accordingly, list after 3 weeks as prayed for. Yes.
This again, TV9. This should hear the native also is for what Lordship is on village man. So this matter will come up on February 6 now.
Learned counsel, Mr. Medovero submits that the leading counsel, who is from Gauhati, is in bereavement and accordingly prays for listing the matter on 6/2 2026. Stop. Learned Councils, Mr. Thibapom PP and as well as Mr. Skitokasu for respondent number 2 are present. There's no objection. List on 6/2/2026 as prayed for. Yes.
Thanks, my lady.
Hmm.
I didn't expect May 2024.
Hmm.
I had instruction to pay for the claimants 1 to 5.
Hmm.
1 to 5, the response 1 to 5.
Respondent
Okay.
1 to 5.
1 to 5. Well, a lot of time to file my power as
Hmm.
well as this thing and this released me directly applying to serve me a copy
Hmm.
of the IA. So that I can if need be, I can
IA is for condonation.
Lordship,
Okay. Heard Learned Counsel, Mr. Fosika Fote, stop. It is submitted that he has received instructions to appear on behalf of respondent number 1 to 5
payments.
and prays for some time to file his power as well as objections in the IA 165 of 2025. So, how much time? List after 2 weeks as prayed for. Stop. In the meantime, the counsel for the appellant is directed to supply a copy of the IA. You have received the main appeal.
No.
Okay, receive
Yes, sir.
to serve.
No, to the public.
Okay, to serve a copy of the IA 165/2025 on the learned counsel for the claimants during the course of the day. You can give today. Within, okay, during the course of the day. Yes.
If I may, Lordship, pay permission item number 19, Lordship.
Hmm.
Lordship, in the previous occasion, the address for the respondent number 2 actually were insufficient.
Hmm.
So we were allowed to check the actual address.
Hmm.
But so far we couldn't find it, so some few time may be granted.
1 and 2.
2 and 3.
Oh, 2 and 3. Learned counsel for the appellant, Mr. L. Pom, submits that he is unable to verify the actual address of respondent number 2 and 3 in order to effect the service. And accordingly, prays for 2 weeks' time to ascertain the address. So prayers allowed list after 2 weeks. Learned counsel, Mr. Medovero, appears for respondent number 1. Stop. Yes. Yes.
I'd like to mention clear item number 13 on behalf of Supermarket.
Hmm.
Lordship, as is out of station, can you do this in about 2 weeks?
Learned counsel, a message as such makes a mention on behalf of the leading counsel, Mr. S. Swalling, for the petitioner to list the matter after 2 weeks as the counsel is out of station. Stop this after 2 weeks as prayed for. Learned government advocate, Ms. Pichano Lota is present. Stop. Yes. Yes.
Permission item number 33 from the supplementary office. In the petitioner, I need to file the affidavit of service, Lordship.
Hmm.
So it is submitted after 2 weeks, Lordship.
Affidavit of service.
Yes.
Oh, you Dusty service.
Yes.
Okay. Learned counsel, Mr. Medovero, appearing for the petitioners, submits that the the affidavit regarding Dusty service has not been filed and therefore prays for
2 weeks time.
2 weeks time to file the same. Stop. Prayers allowed. List after 2 weeks. Learned senior government advocate, Mr. N. Angami is present for the state respondents. So yes.
Lordship, if it can be listed after 3 weeks, I'm also yet to file my contract in this matter.
Mm. Okay, let it be after 3 weeks.
I'm thinking of that.
For motion, item number 1.
This Lordship.
Hmm.
Maluk is arranged for installation of anti-septic gel on 11/15/25.
Hmm.
And anti-septic bill was made obsolete on 28/2025. And anti-septic bill number 5 for 2025.
Hmm.
The Lordship may kindly see the honorable court order dated 11/2/2025. And accept
Page.
page 10 and page 10.
by this order, and this interim anticipation was granted to the respondent.
Hmm.
And
Then it was
it
regularized,
was regularized on 28
28
by
to,
order dated 28/2025. My lord, while granting anticipation to the respondent
Hmm.
for the students on the term and condition to be followed by the during the well-being.
Hmm.
However, till date, the accused, the respondent has not complied the term and condition laid down by this honorable court.
Hmm.
And my lord.
Which condition was not fulfilled? What was the
What?
condition?
Watson regarding the term and condition, page number 10. Page number 12. Let me see the page number 12.
Shall appear
Wait.
on, yes.
In the interim, considering the submission made by the learned counsel for the petitioner is granted pre-arrest bail in connection with so and so on the following conditions. Number one, the petitioner shall appear before the officer in charge, IO of the Deputy PS Dimapur on before 25/2025. In the event of arrest of the petitioner by the police at Dimapur, the petitioner shall be released on executing a bail bond of 25,000. The petitioner, while on bail, shall not tamper with the evidence of the investigating agency or the prosecution witness.
Hmm.
So, my lord, here the in the third condition,
Hmm.
here it clearly says that shall not tamper with the evidence of the investigations.
Hmm.
My lord, here the accused is not cooperating the law. And by us direction given by this order, he appeared.
Hmm.
And his statement was recorded. Thereafter, his recording of his statement.
Hmm.
After that, on 3 occasions,
Hmm.
the IO has sent notice to the accused to appear.
Hmm.
And however, till date, he's not cooperating. The lordship will kindly see the notice in the page number 17. Annexure P, my lord, P16. This is the letter received from the IO.
Hmm.
And here I have received the instruction that to pay the cancellation of the distributed bill granted to the accused. And my lord, here the notice was sent on 3 occasions. The lordship mechanism case number 18, 19, 20. This notice was sent to the accused to appear, but
Hmm.
he has not appeared. Hereafter, the IO has submitted the status report on several occasions. That is page number starting from page number 21. Page number 21, 22, 23.
Okay, well,
The Lord
two
President
notice.
to read the latest last
Hmm.
from 2024, the page number
Page
24.
24.
Yes. Kindly allow me to read this status report now.
Yes.
This so with reference to the subject cited above, I have the honor to state that Mr. So-and-so, who is the main accused in connection with the above reported case, was granted 3 years by the Gauhati so-and-so with on 12/2/2025 with the direction to appear before the concerned IO or before on or before 25/2/2025. As directed, he appeared before me on 19/2/2025 at so-and-so. Subsequently, he was arrested and released on bail bond as directed by the Honorable Court. During his appearance, he was thoroughly examined and his statement was recorded, during which he admitted his involvement in the instant case beyond any reasonable doubt, as requested by so was given a period of 3 months to produce all available documents and witnesses pertaining to this instant case to the investigating agency. But after a lapse of 3 months, he failed to appear before the investigating agency. Therefore, notice under section 35/3 PNSS seeking for so-and-so appearance was served thrice on date 2/6/2025, 23/6/2025, and 21/17/12, but he didn't appear. Consequently, cancellation of his interim bail was prayed to the Honorable Court on 18/8/2025. Subsequently, on 25/8/2025, the Honorable Court passed an order directing Mr. Swanso to appear himself before the investigating officer within a period of 10 days, physically or through electronic mode, if necessary, and to render his full cooperation to the investigating officer. On 8/19/25 at 3:19 p.m., Mr. Swanso appeared before me through electronic mode video conference, which lasted 12 minutes and 49 seconds. It is pretending to mention that the video conference could not be completed due to fluctuations of network from his hands.
After this, did he appear personally?
No, ma'am.
He never
He
appeared.
didn't appear. And thereafter, the court has given a direction to appear.
After that also he didn't
He
appear.
didn't appear, ma'am. The Russian mechanics in the last order, page number 25. The next is C.
Yes.
Para two, onward, ma'am. From the last order passed by on his honorable court, the petitioner was given directive to appear before the investigating officer physically on third clause 25 at 1 p.m. But it is informed by the learned public prosecutor that he has not complied with the order of this court. It is also submitted that in the last order, it has been reflected that white order is controlled that so the petitioner was directed to appear before the investigating officer, but he failed to do so in non-cooperation of this honorable court. It is submitted by Mr. Swanso that the petitioner is suffering from melena, and because of treatment of his ailment, he could not appear physically before the investigating officer. However, he is ready to extend his cooperation with the investigating officer. Further, it is submitted by Mr. Swanso and public prosecutor that the petitioner has already obtained anticipated from this court and taking that advantage, he is avoiding to appear before the investigating officer and not cooperating at all in the investigation. Accordingly, has submitted the anticipated bill granted to the petitioner also be rejected by this honorable court. And
This criminal petition is still pending.
yes, my lord, that item number 29.
Acha, acha.
Today, the counsel for the petitioner has submitted that he is in bereavement. That's what that has been fixed on.
Okay,
Second.
Acha. The present application under section 483 clause 3 BNSS has been filed praying for cancellation of the anticipatory bail order dated 11/2/2025 and 28/2/2025 passed in the anticipatory bail petition number 5/2025. Stop. Para heard learned counsel, heard learned public prosecutor, Mr. Thiba Bom. Stop. It is the contention of the petitioner that right order dated 11/2/2025 in anticipatory bail petition 5 of 2025, this court had granted interim pre-arrest bail to the respondent with the condition that the petitioner shall appear before the IO of the Tipupar PS Dimapur on or before 25/2/2025. Stop. The interim pre-arrest bail was made absolute by order dated 28/2/2025 by this court on the same terms and conditions as laid down in the interim bail order passed on 11/2/2025. Stop. It is the contention of the learned public prosecutor that after the disposal of the anticipatory bail application, the respondent has failed to appear before the investigating officer on several occasions. Stop. Copies of the notices dated 2/6/2025, 23/6/2025, and 21/7/2025 have been produced by the learned public prosecutor, by which the appearance of the respondent had been sought by the IO. And thereafter, the respondent had never appeared before the investigating agency. So, para, it is submitted that the respondent is not cooperating with the investigating agency and is taking advantage of the anticipatory bail granted by this court. Stop. Hence the present application. So, para, issue notice on the respondent returnable within 4 weeks. The petitioner shall take steps. How will you take steps?
My lord, since the criminal petition is pending
Hmm.
and the counsel is also appearing, so can I serve copy to the counsel who appeared in a criminal petition now?
Mhm. Okay, shall take steps for service on the respondent through the counsel for the respondent as the criminal petition number
One of them.
1 of 2025 is still pending before this court, where the respondent is the petitioner. Stop. The said steps shall be taken within 1 week,
Yes.
within 1 week from today. So, on the next occasion, the updated CD, I think, will be necessary. Or is this the latest report?
Yes.
This is the latest report dated 7/12. Okay, just say after 4 weeks, least after 4 weeks.
For motion, item number 2.
Yes, any instructions?
My lord, in the last occasion, petitioner was directed to submit the representation. However, I have not received any instruction.
The approach with the report. Okay, you have submitted.
Yes, Lordship.
Correct.
I have a copy today also, Lordship. This can be placed before this call.
My lord, sufficient time will be given to the authority to consider the investigation. Direction will be issued to consider the investigation.
15/12. Submitted on 15/12.
Lordship, and to the Deputy Commissioner it was submitted prior, Lordship.
Hmm.
No, Lordship, now this is exactly today, from today it's 15 of 1 month, Lordship.
Hmm.
And I just received instruction from my client that nothing,
Nothing
no action was
done.
taken by the government, Lordship.
Learned counsel for the
And Lordship,
petition.
yes, this court has the jurisdiction to take over this matter because I also have citation, Lordship, wherein the Supreme Court said
Hmm.
that when there are 3 criteria laid down, Lordship, when the issue pertains to violation of fundamental rights. This
No,
court-
interim order is already there in
Lordship,
your
yes,
favor.
yes,
So
yes,
let's see.
Lordship, yes.
And let them also get the opportunity to file their counter if necessary.
Lordship, yes.
Yes. To learned counsel for the petitioner, Ms. Nitya Koza, as well as learned government advocate, Mr. Tipapong. Stop. By order dated 8/12/2025, this court had directed the petitioner to submit a representation before the state authorities for the settlement of the issues and regarding the settlement of the issue regarding the excommunicating of the petitioner. Stop. As in compliance of the direction, the representation has been submitted by the petitioner before the Chief Secretary as well as the Deputy Commissioner Mokokchung, before the Chief Secretary, State of Nagaland, as well as the Deputy Commissioner Mokokchung District on 15/12/2025. Stop. However, however, the representation has not been disposed of and no action has been taken by the state authorities according to the petitioner. Stop. The learned government advocate also submits that he has not received any instructions with regard to the representation submitted by the petitioner. Stop. Accordingly, list the matter after 3 weeks in order to enable the state respondents to dispose of the representation submitted by the petitioner, and the learned government advocate shall obtain the necessary instructions with regard to the same on the next date. Stop. List after 3 weeks.
Lordship, let the hearing of
The interim order passed on 8/12/2025 shall continue till the next returnable date. Yes.
Like so much.
So,
For motion from the supplementary cause list, item number 31.
Yes.
Assessment compliant with national law dated 17/4/2025.
Mm,
This is one thing I've been saying also.
mm.
Lordship, the relevant portion is at page 17. Page 23,
Yes.
paragraph 23.
What was the direction?
First direction was given to initiate steps to acquire the petitioner's land, your lordship.
To complete the process regarding the acquisition.
In 6 months was given, your lordship. So it has lapsed on
This-
7 of October 2025.
6 months from receipt. And no steps have been taken.
Yes, I know what I mean.
Second thing. Lieutenant Counsel for the petitioner, Ms. Esther. Stop. The present application under section 11 and 12 of the Contempt of Courts Act read with Article 215 of the Constitution of India and the Contempt of Courts Rules 1970, Contempt of Courts under bracket Gauhati High Court Rules 1977, alleging willful and deliberate violation of the judgment and order dated 17/4/2025 passed by this court in WPC 131/2020. Stop. Para. It is submitted by the learned counsel for the petitioner that by judgment and order dated 17/4/2025, the state respondents have been directed to take steps to complete the acquisition process of the petitioner's land in accordance with the provisions of the Nagaland Requisition and Acquisition Act 1965 within a period of 6 months from the date of receipt of a copy of the order. So it
This
is,
copy was served on 24/4/2025.
and it is stated that the copy of the order was served on the respondents on 24/4/2025. Stop. However, no steps have been taken by the state respondents in compliance of the order till date. Stop. Para. Issue notice returnable within 4 weeks. Stop. The petitioner shall take steps for notice on the respondents 1 to 5 by speed post document within 3 working days from today. List after 4 weeks. Yes.
For motion, item number 32.
This is lordship.
Yes.
Lordship, here the petitioner is a retired mock church. The seeking for variation for regularization of a service agent with the OM 17/5/15 and also with the notification of 5th March 2025 lordship.
Your first appointment,
Is that annexure 1 page 25 lordship.
29/10/87.
Yeah. Lordship, thereafter, inter year again, subsequently 22nd December 2011. She was given a various scale lordship at annexure to page 26 lordship.
22/12/2011.
Mr. During her survey, while she was in survey lordship, she was pursuing her matter for her case for regularization. However, before her regularization, case was considered lordship. She was retired after serving for 35 years.
35 years.
Yes, lordship. That is a match for the ruling issue 30. She was released by order dated 15 November 2022. Lordship.
Actually, this is that
Similar
same
to
case, I guess. There was a litigation also, isn't it?
Yes, Lordship. Yes, same case with the one which I
Yes, yes. That earlier case is an extra 20. No, not an extra 20.
Lordship, in fact, this 20 is the third one, second litigation. Lordship. Yes.
No, no, that order where the court said that the government advocate had received a communication that on
20 from
page 20, no,
Lordship.
an extra 20.
And the notification is on 20, next year 22. Lordship. The one which I have been.
But learned counsel for the petitioner, Ms. Mikai. So the present writ petition has been filed by the petitioner claiming regularization of her service. Stop. It is the case of the petitioner that she or he was appointed as contingency on contingency basis by order dated 29/10/1987, and thereafter she was granted scale of pay by another order dated 22/12/2011. Stop. And she has been retired from service after serving for 35 years. Stop. The petitioner had also approached this court earlier, vite WPC 176 of 2024, which was disposed of on the basis of a written instruction given to the government advocate concerned from the government that the claim of the petitioner and two other similarly situated petitioners who had been appointed on contingency basis prior to 6/6/2016 will be covered by the notification number AR/legal, capital letters, okay, AR/legal -5/8/2024 dated 5/3/2025, and that they will be granted scale of pay as per the revision of pay 2015, subject to fulfillment of the conditions laid down therein. Stop. It is the contention of the learned counsel for the petitioner that in spite of this assurance by the government, and in spite of the fact that the writ petition WP 176/2024 was disposed of in view of the said assurance, the state respondents have again issued a notification. Where is that? Have again issued the impugned notification, page 661. Impugned notification dated 29/2025, by which it was stated that the service of the petitioner will not be covered under the OM dated 5/3/2025. In view of the fact that the OM is effective only from 1/4/2025. Stop. Being aggrieved, the petitioner has approached this court. Stop. Para. Learned government advocate Pichano Kitan appears for the state respondents and accepts notice on behalf of all the respondents. Stop. Accordingly, no formal notice is called for. However, the learned counsel for the petitioner shall serve extra copies of the writ petition on the government advocate during the course of the day. Stop. List after 4 weeks. Yes. And it can be listed together with the other case.
Yes, Lordship.
List along with WPC 256
of 2020.
of 2025.
Lordship.
For admission, item number 3.
Lordship. Lordship,
received a written instruction from the Union Council this morning.
Hmm.
Now, Your Lordship, the Union is trying to wash its hands away. Here, this project, this is the project of the Ministry of Road Transport and Highways.
Hmm.
Now, in the letter, which I believe my learned senior colleague will be handing over to the Lordship for the Lordship's reference. In the letter, they are saying that because, number one, this project was sold after, this project was, the project was submitted by the PW National Highways Nagaland, and they have desanctioned. So now they have no responsibility. They have taken lordship to the contract agreement.
Hmm. What is this actually? You're praying for an arbitrator to be appointed by the court.
Yes, Your Lordship.
Uh-huh.
So now the other party, in the first place, they have made the. Where's the arbitration agreement? Well, Your Lordship,
Hmm.
page 16. Page 16 is the contract agreement. The parties. My Lord, may I kindly come to page 29, that is the relevant portion.
Page 20.
Page 29. The relevant portion. May I read, my Lord?
Yes.
This agreement is entered into on the 18th day of September 2020 between the President of India through the Ministry of Road Transport and Highways, Government of India, represented by Chief Engineer PW National Highway Kohima. So, my Lord, the language is very clear. Through the Ministry of Road Transport and Highways, Government of India, and represented by the Chief Engineer PW National Highway Kohima. Hereinafter referred to as the authority which expression shall, unless repugnant to the context or meaning thereof, include its administrators, successors, and assigns of one, and the other party is the present petitioner, Your Lordship.
Hmm.
Now, my Lord, in the first place, this is the project of the Government of India, the Ministry of Road Transport and Highways. At this stage, just because the project is desanctioned by the Ministry of Road Transport and National Highways, Road Transport and Highways, they are trying to wash their hands off to give the sole, to bear the sole responsibility by the PW National Highways Nagaland. May we read this letter, Your Lordship?
Yes, please read.
My Lord already has received the
Acha.
16th December 2020.
Yes, yes, yes.
This
So
is
that
addressed
they are
to-
trying to say that initially it was
Yes.
entered into between the petitioner and the mort,
Yes,
but it was desanctioned because it does not form part of the national highway network.
but Your Lordship will kindly appreciate it. It's a very lame excuse. Why would they have sanctioned the project in the first place? Then later on, there was a problem between the National Highways and the BRO,
Hmm.
National Highways Nagaland, and the BRO also claiming that this road is ours, and the PW National Highways also claiming it's ours. Now, that is not the main bone of contention in this case, but that was the issue, Your Lordship. Then, later on, because of the dispute, the push and pull, this issue later on was desanctioned by the Government of India, but the petitioner in this case have invested a huge amount of money because the direction was issued to immediately start the work.
Hmm.
Now, after the petitioner has incurred losses, at this stage, whether they can be allowed to withdraw from the case, stating that to wash off their hands, stating that the project has been desanctioned. The other point raised that paragraph 3, Your Lordship will appreciate that they are trying to take the excuse of the SOP dated 22/7/2025.
Hmm.
This petition was filed before this honorable court in the month of February 2024.
Hmm.
Arbitration petition are pending for this long is unknown, Your Lordship. It's almost 2 years since this petition has been filed.
But now it appears that there's a dispute between who should be the party. Even if an arbitrator is appointed, you will be there on one side, who will be there on the other side?
No, they are
Because they are saying they are not.
The Ministry of Road Transport and Highways The other party will be the PW National Highways Nagaland.
We have the above factual position, the work had started, you had started the work.
The arrangements, everything was done.
Mm.
We had broken machineries, also set up the camps for the workers, and because we were not getting a green signal to start actual work,
Mm.
initial preparation was done, and we were for months together. We have invested money there, paying our employees.
After that, it was desanctioned.
It was desanctioned after that. So we had to withdraw all our machineries, and then it has led to incurring huge loss for the present petitioner.
So what is your objection towards appointing an arbitrator? What is the objection?
In my affidavit,
Hmm.
page 4. The bureau is not in my affidavit.
Respondent one.
No, the bureau, or the is not in this case.
Oh,
Without because the land has not been in the bureau.
hmm.
Even without going to the my affidavit process, the bureau is not complete.
Union of India, Chief Engineer, PWD.
Or not being the part of this one.
No, but who,
So there is no party in the agreement, also, Your Lordship.
they are not the party in the agreement. And who issued NIT?
They could not be declared for the project work due to the alleged non-handover of the project stretched by the BRO. That is our second one.
No, that is a different issue. But who issued the NIT? And who was the sanctioning authority? It was the MOT.
But we have already.
NIT was issued by the, no, that is a later development. But initially, who issued the NIT? NIT was issued by Chief Engineer, isn't it? PWD?
Yes, Your Lordship, because he was the appointed representative of the Ministry of Road Transport and Highways.
I think on the last occasion, the court even asked the state respondents to suggest for an arbitrator, isn't it? Hmm.
After that, Your Lordship, we have received the circular dated 22nd of July 2025. Now, Your Lordship, this, if I make allowed to make a submission on the circular, though of course, this circular dated 22/7/2025 has been discussed at length before this honorable court.
Hmm.
And one particular para, Your Lordship,
Hmm.
which says in the circular, if I may be allowed just to read this para,
Hmm.
to make it clear, Your Lordship.
Hmm.
My lord, I have placed this circular dated 22/7/2025 before this honorable court.
Yes,
I
yes.
have placed it on report. The first page, Your Lordship. The first page
Hmm.
that starts with the sentence Ministry of Road.
Hmm.
If I may be allowed just to read this para, Your Lordship.
Yes.
Ministry of Road and Transport and Highway MRTH is responsible for development and maintenance of national highway in the country. State PWD, RCD, BRO are executing agencies for development and maintenance of national highway entrusted to them. Thereby, Your Lordship, this is important. Any decision on contractual or any other matter referred to litigation or arbitration or court having financial implications shall be taken by the state PWD, RCD, BRO only with prior approval of the MRTH. This is the reason why, Your Lordship, this honorable court has passed an order asking us to send all the documents pertaining to these arbitrations before the ministry. We have placed it, Your Lordship.
Hmm.
And now they are coming up with this letter stating that this circular does not apply to them.
Acha. This is after you had submitted the
Yes.
papers.
Yes, Your Lordship. And this particular circular dated 22nd July 2025 has been discussed at length before this honorable court, my lord.
Desanction the said project.
The Lordship, considering this development,
Yes.
I have two submissions for
Hmm.
consideration of this one-line submissions, Your Lordship.
Hmm.
Now, the arbitrator, if appointed, is to decide whether we have actually incurred loss. Now, the second issue now is, Your Lordship, this letter trying to wash off its hands now at this stage is not acceptable.
Hmm.
So this letter may kindly be
No,
rejected by this own court
this
and
will not
next
do.
date.
Yes, because the agreement is already there
Yes, Your
between
Lordship.
the three parties.
So let them come with any instruction on whether they are agreeable to the proposed arbitrator, Honorable retired Justice V.K. Sharma, whether they are agreeable to that or not. If that order can be passed, Your Lordship, because this
Of
letter
course, his
itself-
name is not there in that list issued by the High Court.
Yes, Your Lordship,
Hmm.
but
List
we
of
approached him
arbitrators.
and then he agreed. So that's why we, subject to the consideration of this honorable court.
I'm just wondering whether the court can appoint someone who is not in the list. Hmm.
Your Lordship.
The arbitrator is appointed,
Hmm.
it should be as the list of the.
Your Lordship, Your Lordship.
It has to be as per the list.
List.
So in the list, I think Justice Koza, do you have that list of arbitrators?
No,
It's there somewhere in the registry. Can you just place that list? No.
Lordship, the latest list was issued in 2025. I have gone through also. It is not there. Justice V.K. Sharma.
His name is not there as far as I know.
Yes.
So can you just place that list and then we'll put it next week? You'll have to decide because you cannot wash off your hands now. Because you're already there in the agreement. The agreement is already signed. Okay.
And also, Your Lordship,
Yeah.
taking into consideration the circular issued by them,
Hmm,
they should honor their own circular, Your Lordship.
No, not only that, since you are all parties to the initial agreement, you are responsible. Mr. Joshua Sheki appears for the petitioner as well as Mr. Yangarwati for the Yangarwati CGC and Mr. Enangami for the state respondents. Stop. At the outset, the learned CJC, Mr. Yangarwati, has produced a copy of the letter dated 16 December 2025. Written by, who has sent this letter? Written by the executive engineer for Regional Officer Civil, in bracket Civil, Gauhati, Ministry of Road Transport and Highways, Regional Office, Gauhati. Stop. By the said letter, the authority has stated that the project involved in the instant arbitration petition was originally sanctioned by the ministry on the proposal of the state PWD Nagaland. Stop. Subsequently, after detailed deliberations and examination of records, the ministry has desanctioned the said project on 2/5/2025 on the ground that the road for which the project had been sanctioned does not form part of the national highway network. Stop. In view of the same, the letter states that the ministry's SOP dated 22/7/2025 for dealing with matters referred to the Dispute Resolution Board and arbitration awards or court cases related to national highway projects entrusted to the state PWDs, RCDs or BRO is not applicable to the present case. Stop. Para. In spite of the said letter, this court has perused the initial agreement which was entered into between the parties, and that one was the first page of the agreement.
The first page is page 16,
Page
and the party's name is reflected at page 29.
16. 29. Last line, what did I say? And which was which was initially entered into between the parties, shows the Ministry of Road Transport and Highways, Government of India, represented by the Chief Engineer, PWD, National Highway, Nagaland, as one party, and the MS Multi Builders as the other party. And the agreement was entered into on 18th September 2020 between the parties as mentioned herein above. Stop. Accordingly, this court is of the view that the respondents cannot shift the responsibility at this stage, and this court is inclined to appoint the arbitrator as prayed for by the petitioner under section 11 of the Arbitration and Conciliation Act 1996. Stop. The registry is directed to place a copy of the notification issued by the Gauhati High Court with a panel of names who can be appointed as arbitrators on the next date. Stop. List when?
Your Lordship,
List on
what date?
27th. Or we can give on 21st. No, that's Wednesday. 20th. List on 20.
20.
Yes, 21.
20, Lordship, not be here 21st.
Okay, 21st is a Wednesday. Yes, 22nd. List
Can we
on
list it on 19, my Lord? 19 is
Monday. Okay, list on 19/1,
No,
2025.
Lordship.
For admission, item number 5.
The petitioner's counsel is always vegetarian.
Oh, that's. Put it here. Put a copy here. Yes. Government is yet to file.
Your Lordship, no, I'm representing respondent number 2 and 5, Your Lordship.
Oh, sorry, this is contempt petition.
Yes. I have already filed my affidavit showing the steps taken by me to comply with this order of this honorable court. But this is contempt is relating to regularizations of petitioner service, Your Lordship,
Okay.
as per the 2015 office memorandum.
So steps are being taken.
Steps, yes, Your Lordship, from the office of the respondent number 2 and 5. Lordship, whatever steps are supposed to be taken, we have already taken, and then we have placed it before the PNR department. They have sent certain queries, we have replied back to those queries as well.
You wait for some time then, Learned Counsel, Ms. Such and Such appears for the petitioner. So Learned Counsel, Mr. N. Nankami appears for the respondent number 2 and 5 and submits that the process for regularization of the petitioner is already ongoing and the file has been processed to the PNR department for necessary steps. Accordingly, it is prayed that some time may be given to the respondents to comply with the direction of this court. So, accordingly list the matter after 3 weeks.
4 weeks.
After 4 weeks. After 4 weeks, as brief. Yes.
I'm deeply obliged.
For admission, item number 12.
Yes.
Yeah, we've got an ability schedule.
Hmm.
So I got this maybe was about it. Something like it. Lordship.
Yes.
I have no objection into that. This is after the total of the appeal.
Hmm.
It's number, I don't know.
Number, read the appeal number.
I probably distributed. But
You
the
should
lordship-
get the number before submitting.
Yeah.
Mm.
The lordship,
Yes.
this is the order, take this 17 the letter.
Mm.
17.
Regarding Vakalat Nama, you
So your
to
lordship, as directed by this noble court, I have filed affidavit of service.
Okay,
On respondent number 1, 2 and
1, 2
4.
and 4. Mm.
And I am informed that the General Counsel Gauhati will be appealing for respondent.
One,
The several CPA are so far, but I'll be very honest now.
respondent 1.
So I'll be agreeing on the all this sort of stuff.
Then what about this? It says, in the meantime, the learned counsel Ching Yang Pom,
Yeah.
appearing for R3 and 5, submits that Vakalat Nama had been filed. However, there was some discrepancy and therefore it was rejected. He is praised that he may be allowed to file the correct Vakalat Nama on behalf of respondent 3 and 5. Yes.
Your Lordship, of that occasion, I was meeting on behalf of my senior Your Honor. Your Lordship, I would be separated. I still await it, I still await it.
But you will be appearing
Yes.
for all the respondents.
That may be recorded.
Okay. Learned Counsel, Mr. T.B. Jamir appears for the petitioner. Stop. Learned Counsel, Mr. Yangarwati appears and submits that he has received instructions to appear on behalf of all the respondents and that he will be filing his Vakalat Nama shortly. So, in the meantime, Learned Counsel, Mr. Yangarwati also submits that a writ appeal has been filed by the respondents against the judgment and order. Judgment and order, page
21 for.
against the judgment and order dated 21/5/2024, passed in WPC 76 of 2022. Stop. And therefore praise that the present petition may be listed after the disposal of the writ appeal. Stop. The learned counsel for the petitioner shall provide the number of the writ appeal on the next date. We'll give you another date next week and then you just place the writ appeal number, okay? To place the writ appeal number on the next date and thereafter necessary orders will be passed. So list the matter on 19/1/2026. Yes.
For admission, item number 13.
It's your lordship.
Hmm.
Lordship, I will be making an appearance on behalf of the respondent number 13.
13.
Or respondent number 10.
Respondent 10. Hmm.
May be allowed to file my power within 1 week.
Okay. What about the other respondents?
I'm representing respondent number 1.
Your issue and representing respondents 5 and 6.
Respondent 5 and 6.
The other respondents are represented by Miss A. Anumi.
Okay. Okay. Learned counsel for the petitioner, Ms. Such and such is present. Learned counsel, Mr. N. Nangami appears for respondent number 1, comma. Learned counsel, Mr. Your name for respondent number 5 and 6, and Miss A. Ayemi for the other respondents. Stop. Mr. Joshua Sheki enters appearance for respondent number 10 and has prayed for some time to file his Vaklatnama as well as his affidavit, if so advised. Stop. How much time? List
Kindly give me
two,
2 weeks time.
list after 2 weeks. Let's prayed for. Yes.
Plus,
For admission, item number 15.
And for the corresponding in the time, get to file when at the beginning of this.
Government has also not filed. None appears for the petitioner when the matter is called. Stop. Learned counsel, Ms. Such and Such, appears for respondent number
Number 5.
5 and has prayed for 2 weeks. 2 weeks time to file the counter affidavit. Stop. None appears. Who appears for the government? Mr. N. Angami appears for the state respondents and has made a similar prayer. Stop. List up to 2 weeks as prayed for. 2 weeks. I think Inaholi is appearing.
For others, item number 17.
Please,
Hmm.
I'm appearing for respondent number 1 in this matter.
Yes.
There was a new improvement because of the change of guard.
Respondent 4.
Yes, respondent number 4.
Service report still awaited. Okay, learned counsel for the petitioner, Mr. Sergeant Such present. Mr. N. Angami, learned counsel, appears for respondent number 1. Stop. The petitioner has taken steps for service on the newly impleted respondent number 4. However, the return service report is still awaited. So accordingly, list the matter after 4 weeks.
Yes.
For others, item number 18.
Lordship, a similar order may be passed. These two are connected, the Lordship, and the respondent number 4 is the same respondent.
Okay. In this 18 also.
Yes.
Okay. So and here also you are appearing for R1.
Yes.
Okay, then same order.
For others, item number 20.
Lordship, here was for the same council,
Hmm.
is another station.
Okay. Okay. Learned counsel, Ms. Such and Such, appears on behalf of Mr. S. Walling, counsel for the petitioner, who is out of station. It is stated that service of notice upon respondent 1 to 3 had been taken through registered post. However, right office note dated 12/1/2026, the service of notice upon the respondent 1 to 3 is still awaited. Stop. Accordingly, list the matter after 4 weeks, awaiting service on the respondents 1 to 3. Yes.
For others, item number 21.
None appears for the petitioner when the matter is called. List after 3 weeks.
For others, item number 22.
Yes. Steps taken.
So we
You're appearing.
Yes. Lordship, I'll be appearing for respondent number 1 in this matter.
Okay. Learned counsel, Mr. A. Sophie appears for the petition. Stop. Learned counsel, Mr. N. Nangami enters appearance on behalf of respondent number 1. Right. Office note dated 12/1/2026. It is indicated that the return service reports on the respondents 2 to 5 is still awaited. So, Accordingly, list the matter after 3 weeks awaiting service report on the rest of the respondents.
For orders from the supplementary cost list, item number 34.
Is for amending the post title by including DC Woka as response number 8, Your Lordship.
Earlier, DC was not impleted.
Yes, Your Lordship, it was an inadvertent omission, Your Lordship. The order has already been challenged, but.
Hmm.
Yes, Your Lordship.
Any objection? Will allow? It is just a technical,
When filing the petition, you should have included the
Deputy Commissioner.
present deputy commissioner and the ADC as the party respondents.
Hmm.
We filed objection.
Hmm.
It is raising objection and we raise objection with regard to the maintainability of the writ petition.
Hmm.
For none, when there are necessary parties, the writ petition is liable to be dismissed.
Hmm.
That has made them wiser and then now we are coming with the application for employment. Since it is, as Lordship has correctly pointed out, this is a technical nature.
Hmm.
I leave it to your Lordship.
And
We can contest in the.
everyone makes mistakes sometimes, so.
Inadvertent mistakes.
Yes.
Is what happens.
Yes.
It happens.
It happens to everyone. The present application has been filed by the petitioner, praying for amendment of the petition in WPC number 227 slash, it should be cost title only, I think, for amendment of the cost title in WPC 227/2025. Stop. Learned Counsel for the petitioner, Ms. Esther, as well as Learned Senior Counsel, Mr. Sri Jamir,
3, 4, 6 and 7.
for respondent number 3, 4, 6, and 7, assisted by Aliba Uzakam. Stop. Okay, Learned Counsel, Mr. Tiba Pom appears for the additional AG, Mr. Im Tim Song on behalf of the state respondents. Stop. As Mr. Fosika Fote appears for respondent number 5. Stop. The prayer of the petitioner in the present application is that the writ petition number 227 of 2025 had been filed by the petitioners, challenging the order dated 4/11/2025, which had been issued by the additional Deputy Commissioner Walker. Stop. However, due to inadvertence, the Deputy Commissioner Walker as well as the additional Deputy Commissioner Walker had not been impleted as party respondents in the said writ petition. Stop. It is also submitted that the petition filed by the applicants raises important questions of law, and it is prayed that there would be grave miscarriage of justice if the applicants are non-suited on such a technical / procedural issue. Stop. It is therefore prayed that the amendment of the cost title may be allowed. Stop. Para. The court has considered the application, the prayer made in the application, in is of the view that the writ petition may be allowed to be amended the IA may be allowed, and the petitioners may be allowed to, petitioner/applicant may be allowed to amend the cost title by impleting the Deputy Commissioner Walker and / additional Deputy Commissioner Walker. Stop. As respondent number 8. Stop. Petition is disposed of. The petitioner shall file the necessary amended cost title in the before the registry. Yes.
May I please, my lord, sorry for interruption. In item number 1, kind of allow me to serve notice through registered post, my lord. Counsel for the counsel is not accepting, my lord.
That item one, na, who, I think it was mining. Instead of through the council, just say the petitioner will be allowed to take steps through, not registered, it will be speed post, through speed post document on the respondent, okay? Yes, it has not come. Okay, you let me know when it comes down, okay?